It is August 27th of 2026, and this is the Court Gallery. Today's compilation features a colorful parade of defendants who simply cannot follow the rules. We kick things off with a confused business owner facing 5 separate probation violations, completely baffled by basic scheduling. Then, we meet a frequent flyer who racked up 9 separate warrants after causing disturbances at restaurants and fire stations, yet still claims to be the victim of a massive conspiracy. Yep, it's September. Later on, a defendant makes the ultimate bad decision by using the jail phone to call the exact person the judge explicitly ordered him not to contact. From endless excuses to baffling courtroom behavior, buckle up. All that and more starts right now.
Jeremy Kristen Anto Robertson, file 25W83764. Mr. Roberts, how you doing today? Your name? Mr. Roberts, you are back here. See me, right? You like, right? You don't have to answer that. All right, listen, you have 4 violations now, again, right? 5 now. Count 1, failure to attend your scheduled probation visit on August the 5th. Count 2, failure to attend the court work program on July the 11th. Count 3, failure to attend the court work program on July the 25th. Count 4, failure to complete the positive strategies program. And count 5, failure to pay fines and costs as ordered, balance 1758. Those are the charges. If you plead guilty, that would be 5 different technical violations. You could be incarcerated on this for up to 90 days. Do you understand that? Did you sign, read, and understand the advice of rights form here? Just make your voice up for me, if you will, please. If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. So you have the right to a lawyer. Be happy to give you one at public expense if you want one. Would you have a lawyer?
Yes.
I'm entering not guilty plea for you, okay? And I'll give you a lawyer. We'll conduct that hearing now. And we'll take this to a lawyer. You'll meet the lawyer. The lawyer will maybe talk to the probation officer, maybe not. You'll come back in front of me and we'll go from there. Do you have any questions?
Sir.
All right. See you in a few minutes. Good luck. People against Jeremy Christian Anto Robertson, 25W837064. All right.
Hey, Michael, he's like 117. Certainly was supposed to be Jeremy Kristen.
What is he going to do on these?
Judge, he's going to plead guilty with explanation, and then
I can't wait to hear it.
thank you.
Mr. Robertson, is that what you want to do?
Sir.
That's 5 technical violations, and you understand, sir, that if you plead to these, that'd be more than 3, obviously, and on the 4th or subsequent, I can order probation revocation. You understand that? And a jail term for the max, which would be in this case, let's see, what was the charge here? 90 days. You understand that? And did you sign, read, and understand the advice of rights?
Sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
The charge, you failed to attend your scheduled probation visit on August the 5th. How do you plead? You got to keep your voice up, nice and loud.
Guilty with explanation.
Did you fail to keep that appointment?
Yes.
Count 2, that you failed to attend the court work program on September or July the 11th. How do you plead?
Guilty with explanation.
You failed to attend on that day?
Yes.
Count 3, that you failed to attend the court work program on July 25. How do you plead?
Guilty.
Did you fail to attend on that day?
Yes.
I mean, I don't really need to hear the guilty with explanation. It's either guilty. You're always entitled to make an explanation. Okay, I want to be clear about that. Count
Might
four.
just come from me.
Well, I got it. Count four that you failed to attend the positive strategies program. How do you plead?
Yes.
Did you fail to attend the positive strategies program?
Yes.
Count five that you failed to pay your fines and costs as ordered. Balance owing as of the time of the show cause $1,758. How do you plead to that?
Yes.
Keep your voice up. Did you fail to pay your fines and costs as ordered? Did you fail to pay your fines and costs as ordered?
Yes.
Anybody force you to plead guilty to these? I'm having a hard time understanding all this, so I want you to enlighten me. Can I have your name, Ms. Wilds?
It's a probation order.
What is going on?
Judge, here's what I see. I see a person coming into probation, ready, willing, and able to participate, but is not understanding the process to get him moving and have that gate drop and have him go. He's a little confused as far as missing the
Wait a
gate
minute.
on
Wait,
August 5th.
whoa. What are you confused about?
He was seeking direction for allegation 2 and 3. He doesn't understand the process, and 4. He doesn't understand the process coming right out of the gate. He did miss on August 5th, but he's claiming he made a phone call.
Can I ask
but
a
he also
couple
had work.
questions? Can I ask a couple questions? Did he graduate and does he work?
Yes,
You graduated?
yes.
From where?
Well, part of still
Where do you work?
almost for no writer.
I can't hear you. I remember now. Well, wait a minute. I'm having a hard time with this. You're running your own business, right? Yes. You're capable of running your own business. You graduated high school, and yet you're not understanding the process of you have to do the court work program on this day. You have to report to probation on this day. You have to do the positive strategies program on this day. You're not understanding any of that? Are you honestly telling me that? I don't believe you.
It's just, it was a lot of paperwork and I was asking questions on what these things are, like if it's all fine thing or not, but I wasn't understanding. I did reach out to my probation to ask these questions, but I wasn't given, the full amount of help.
Did you sit down and interview or
Yes.
hang on, slow down. I'm asking her this question. Did you sit down and instruct him?
Yes, Sharon, he was actually instructed in person. So he was instructed in person, not even by Zoom, received all of his paperwork. Yes. I met with him a second time as well, covered the information again in person. And then he missed his appointment on August 5th.
Did he tell you he didn't understand?
At the first appointment, he did, and we went over everything very thoroughly. I highlighted his order. He received again everything in writing, which even if confused, would spell out where to go for the court work program, on what days to go for the court work program, all of that information, Your Honor.
I don't know what we can do to help you understand it, sir. I mean, it seems certainly like you've got the mental faculties to understand this. You graduated high school, you're running your own business. She sat down with you twice. It's very simple. Court work program day, you appear here at the designated time. What time they appear again? 8:15?
8:30 to 1:30.
8:30. Yeah, but you should get here at 8:15 so you're not late. And you serve 8:30 to 1:30. Period. And when it's time to report to probation, whatever time you're to report here, period. And by the way, I even told you when I ordered the fines and costs, if you didn't have the money, what did I tell you? What did it?
Give you guys a call.
Did you do that? No. You're being highly irresponsible, Mr. Robertson. You're not going to like how this is going to turn out if you don't pay more attention to this. I mean, come on.
Your Honor, may I?
What, are you smiling? You're not smiling, are you?
So I had a question, but I wasn't trying.
Well, then ask your question. What's your question?
That was not a question. Can I make a statement?
Yeah, absolutely.
Trying to get correct. It's not easy to communicate with patient. And that, she noticed the first day. It's like I just was quiet, even though I didn't understand. I was staying quiet because I didn't want to create confrontation. I didn't understand some of the things, so I just stayed quiet until it was over.
Can I ask you a question? I mean, no disrespect by this. You don't have a learning disability, do you?
No, sir. But if I don't have an understanding of what's going on, I do have to ask questions. I believe we do have a right to ask questions. And the question wasn't answered.
What was your question?
I wanted to know about the work program. I mean, not the program, it's something I have to do online.
Positive strategies program?
Yeah, I believe so.
Well, I'm having a hard time understanding what what is your question though? What is your,
I just want to be shown. I know I'm grown, I graduated, but I like to be shown. But it's my first kind of probation here. I didn't understand the policy. So I just wanted to get help with that without signing like a person who's incompetent. I just wanted to get that help and I didn't get it.
Yeah, what I would recommend is.
so that's the positive strategies. She understood you were going to be on the core work program on those dates, right? She gave it to you in writing, right?
Yeah, I just forgot those things.
Oh. You're not paying very close attention. I dismissed a show cause against you back on May the 7th. And I didn't need to do that, but I did. And I said you pay 50 bi-weekly and you didn't pay anything. And then you came in July 16th, found it to pay 75 today, then 50 bi-weekly beginning July the 30th. Paid 73 that day. You didn't pay anything on July the 30th or August the 14th or. I mean, you seem like a nice kid. I don't have you're not, but I don't know what else to do with you.
May I make a suggestion?
I'd love to hear one because
I can go back if it's feasible. I can go back in the probation department with the agent and my client. You can sit down, we can recap. I can be there with my client.
All right. Okay.
Assistance.
Okay. Here's what I'm gonna do. I'm gonna set a sentencing date. I'm setting a sentencing date. Beth, I'd like you to reschedule him on these things. Give me a date in about 6 weeks, Heather. Like early October, and we're going to get him on the court work, help him do the positive strategies, or at least how to get online, or explain it to Mr. Baldwin so he can explain it. And give me a sentence date in October, Heather, please.
Early October, Judge?
Yeah, whenever, if Mr. Baldwin's here, great. If he isn't, well, we'll have to deal. Yes, the first week of October.
We could do October 1st or October 8th.
Let's do October the 8th at 9:30 in the morning.
I won't be here unless you're asking me to.
No, I know. We'll have another lawyer cover this. I mean,
And Judge, just so that you're right, I won't be here either on October 8th. I'll
Are you-
want to be out of the office at the beginning of October.
you gonna be here October 1?
The 14th, no, I'm gone September 29th or.
Hang on a second, guys. I gotta give a new date here. Can I do like October the 15th or something? You can-
Yeah, I do.
Pass on the court work program.
Hang on. Are you gonna be back October 15th?
I should be.
Okay. If I need to set it later, I'll set it later. It doesn't matter.
It's the 15th. What date of the week, Judge?
October 15th is a Thursday.
Be back then.
Let's do October 15th at 9:30, Heather. And,
Okay.
and I will at least pay more attention to this, Mr. Roberts. Okay?
How many payments between now and that date, Judge?
I mean,
Or just schedule work program and
Schedule court work program and teach you positive strategies, and I expect you to start making your payments. I mean, I can't believe when I tell people this, that they still choose to not even contact the court. I just don't understand. I mean, I don't know how many judges do that. Tell people if you don't have the money, contact the court. I tell everybody, and so many don't pay and don't take me up on it. And then I'm supposed to be understanding. I just don't understand it. Start making your payments. Start being an adult. I think I told you before, I think you need to supplement your income. You don't make a lot, do you? How much?
Some days busy, some is not.
You know, but on average, how much you make per week?
I did that for everybody work.
I said per week, not per day. No, I said per week.
Yeah, 400. 400.
Okay, I thought you said on a good day, 400. You're saying on a good week, you're making 400.
That's what it is.
That's $20,800 a year. That is poverty level. So you're going to either have to make up your mind, I think, that you're either going to get another job while your business starts to grow. I don't know what to tell you. I mean, you know, we want everybody to do what they like to do, but sometimes if you can't put food on the table, you got to find something else.
It's this charge is hard to start a job. I do have a Iowa license, but because this comes up, I'm just trying to get it off so I can start a real job because I did apply to kind of make it better for me. But
Well, you do everything you're supposed to do, and this is going to come off your record. Okay?
it's his prior record that's probably affecting. It's the felonies and the weapon
You
charge.
got felonies and weapon charges? I don't remember. You got what other felony?
As I don't know. CCW.
Good luck. I
Thank
wish you
you,
well.
Judge.
We'll see you here. Go down, get your notice. Try to figure everything out and take care of it, please. Good luck.
I got another week.
Shows, that's all we got for here.
Yeah.
Yeah, yep, good enough.
Oh, yeah.
Thanks. Frank Joseph Renna. 260-648-919 A, B, and C.
Judge, just to let you know, we are canceling multiple warrants right now for Frank Renna.
You're canceling what?
Multiple warrants?
Mr. Renna, your name?
Frank Joseph Brown.
You got warrants. You don't like us. You don't want to show up.
I'm
Huh?
trying to clear everything up. I'm
You only got 1, 2, 3, 4, 5.
there's a couple
Believe
Hang
we
on. 6, 7, 8, 9, 10, 11, 12 warrants. And a good portion of them are out of this court. You might as well come in with a big flag that says, I don't have any respect for the court system or the judicial system or our democracy. You not going to play that game with us. You understand what I'm telling you?
Yes.
Well, don't look at the screen there. Look at me. Well, I see no reason to go ahead and arraign him now. Cancel those warrants. We'll get everything in here and we can go through the multiple files that he has.
Stephanie's
most
working
of
on it
them are
right
out of-
now.
Looks like most of them are out of our court. Have a seat, sir. Frank Joseph Renna, 25B148513A and B. He's got a million cases here. 25B148513 C, 25B147939A, B, 25B147939 C, 25W838464, 260-648919A, B, and C. All right, Mr. Shemke, what do we got here? Your appearance?
Good morning, Argus. Shannon Perry of my clients, Nancy Lane.
Mr. Renna, your name.
Joseph Bruno.
It's nice to have you here.
Nice to be back again.
We've been waiting for.
It's a long time coming. I'm a different man walking this working today than I was. There's a lot of mistakes.
Where do we start with this?
Your SC arraignment, I'm a case of the narrative. We wait for more
On the
readings.
retail fraud, 25.838.464, minor and not guilty plea. Jeez. I'll indicate he stands mute on the civil infraction 25B148513C. I'll indicate you're like a different man. I don't know what that means. And then, hang on, I gotta look at it. He's got 10 files here. We're gonna have to take our time here because he's got so many files. I've got to look at these. He's got another civil infraction, 25B147939B. I'll indicate he stands mute and waives formal reading on that. He stands mute and waives formal reading on 939A. He waives reading and stands mute. Jeez. For 939A, which is a civil infraction. He's got a pending possession of the controlled substance in front of Judge Hessen. I have to indicate he stands mute on that. Waives reading. I'm going to have to come back and address bond on all of these. So that one stands mute. Issued a couple warrants for your arrest on these. Probably hasn't been going to AANA as Judge Hessen ordered back on June the 11th of 25. And bet you on the correct on that. And then here on this, let's see, got another possession of a controlled substance on 25B148513A. And on B, possession of drug paraphernalia. Not guilty pleas on that. And on 266489198, that's a drive while suspended. I'll enter a not guilty plea indicating stands mute on those. He's in default on, is he in default on B and C? No, he's not.
On,
I'll set those for hearing on 648919 A, B, and C. I'm setting a bond on that. That will be on the suspend charge. I just got to get these organized. On 25B148513A and B. We're going to have to set a bond on those, including C. Those are in front of Judge Hessen. And then he's got 25B147939A, B, and C. And then he's got another one on 25W838464. What do you have to say?
Your Honor, my client did make substantial change. He indicates he's now 10 months sober. He's out of Suboxone. He discarded some toxic addictions. He does live with his sister and brother-in-law, and he is gainfully employed as a brick mason doing construction. He indicated that last year he was suffering from severe substance abuse issues, but he's maintaining his turn corner and he's dedicated to sobriety.
I hope he's got some money with. What caused him to come in here today?
Your Honor, he just indicated he was ready to take care of these matters.
You saw the light, right?
He did come with some funds today.
Good. Probably not enough though, right?
Well, that's times Judge. He did maintain and he brought in $275.
So I'm not quite sure I'm understanding. Give me 1 second. These always end up with like a mess when these guys don't come in like this. You know what I'm saying? Just a mess. All right. On the July 24th case, I'll give you a personal bond on me. That's personal bond of 500. That covers 23, just so you're clear, Heather, 26T 648-919 A, B, and C. You cannot leave the state. In all of these, you cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. Do you understand all that? Now, on 8513A, B and C, 1,010%. Cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I want you going to AANA 3 times a week. AANA 3 times a week. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs of any kind. Do you understand that, sir?
Yes, sir.
So that will cover 25B, 148, 513, A, B, C. Hang on a second. I'm ordering 1,010% on the retail fraud. You're not to enter or go near Myers store. You're not to enter or go near 22600 Allen Road, that being the Woodhaven Myers. No contact with Meyer employees. You do have to go over to get fingerprinted and photographed at the Woodhaven Police Department on that today. 1,010% on that one. Now, on the other drug charge, I'm simply going to say $75 cash or surety. $75 cash or surety. So you're going to have to post that $275. And I'm going to say C, bond conditions. No contact with prosecution witnesses, no alcohol, marijuana, or illegal drugs. Attend AANA 3 times a week. Again, can't leave the state, can't violate a law. You must appear in court as directed. Heather, I think that covers it. I don't know.
We didn't do the dates though.
Yeah. So now I get to play with that, right? So what do we have here? I'm looking at September. Are they all September 2nd?
I think we tried to keep the ones we could for Judge Hessen and us on the same date.
So I'm going to do September. Look, I'm just going to let you start
You
off
can-
these, will you please? Because
if John can bring the file, if he can bring them down, I'll get them all.
Yeah, I got so many communities involved there. I don't want to make a mistake. So you're going to go down to the hall and get your court dates. Any questions? He's going to post the 275. So John walked down with them. You post the 275. Good luck to you. Oh, Jaden Tide Forrath, 26G306892.
Your Honor, thank you and good morning. James W. Murray for P4847. Appearing on behalf of Mr. Polrath. Please state your full name.
Good morning, Your Honor. Correct.
Does he stand mute? Oh, no, we already arraigned him, right?
Yes, there should be a plea agreement, Your Honor, in the file and 2 pages of police report for the purposes of the
So they're going to give you disturb the peace. It's going to be under 771.1. They're going to dismiss the A and B. And it's going to be a no contest plea, right?
That's correct, Your Honor. And
And you mark this. You stipulate I can use the police report to establish a factual basis.
I do.
If you plead to disturb the peace under section 771.1, the possible penalties are up to 500 fines, 90 days jail, costs of all those. I'll dismiss the A and B. A no contest plea has the same effect as a guilty plea, and presumably it has the possibility of civil litigation, correct, counsel?
That's correct, Your Honor.
So you understand all that I said, sir?
Yes, Your
You
Honor.
plead no contest. Again, it has the same effect as a guilty plea. So I just want to be clear about that. But I'm not going to be asking you a lot of questions and none about the incident. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand the advice of rights?
Yes, Your Honor.
You plead no contest. You'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, Your Honor.
All right. To the charge, disturb the peace. How do you plead?
No.
All right. I'm having this report. I've had it marked and review it. Gosh, I didn't like assaults. I gotta tell you, never had, never will. Are you on probation or parole?
No, you're,
Anybody force you to plead no contest?
no, you're.
Please accepted. I'll take it under section 771.1. I'm going to order a screening and assessment or set a sentence dates. Lead River Village is just a lot of bad things happen over it, seems like.
Pardon me, before we leave the case, would you consider instant sentence?
I'll sentence him, but he's going to get the worst I'm going to think about. I'll tell you right now. I'm not just rushing through this. They wanted to give him disturb the peace. That's fair. He punched the guy 4 or 5 times, it says. I'm not going to sentence him now. No way. He's going to have a pre-sentence report. And he'll come back for sentence. Okay?
Understood.
We'll give you a sentence date. What do you have, Heather?
We can do September 10th at 8:30.
September 10th at 8:30. Is that good with you?
We'll make it good, Your Honor.
All right, we'll see you back here then. So, sir, you're going to go down the hall. You're going to get your notice, and then you're going to go over probation where you'll be interviewed. Okay?
Thank
Best
you.
of luck. Thank you.
Thanks.
Nicholas Agee. 17B 81526A B.
No. No. Hi. I'm Lone Wolf, and I just got a huge donation super chat thingy from Vega, and oh my god, you are crazy, and I love you so much, and thank you, and the channel thanks you, and I don't know. Oh wow, I'm just an idiot. Back to whatever we were just doing. Golly.
Morning, Art. Chairman, fine, stage time, we alone. Station door, sir.
Nicholas Agee, sir.
Why did I give him a personal bond? What's wrong with me? I gave him a personal bond in 2017, and then I gave him or 1,010%. He forfeited the bond, then he shows up August 30. Wait a minute. What year did I give him a personal bond? I wrote August 30 of 21. Is that true?
Let me take a look here, Judge.
I hope he's got some money.
You
'cause he's
gave
got-
a PR, yeah, August 30th.
Why did I do
21
that?
gave a PR.
I don't know why I would have done that. What's going on with him? Now he comes in here and he's gonna ask for more time to pay, because I'll tell you what, if that's the truth, he's not getting it.
Your Honor, I did indicate that he was in custody for a period of time, I believe 2017 to 2021. He's in a much better position now, though he does work for Midwest.
He has, listen, we've never adjudicated this case. Never adjudicated this case with Brownstown and suspend. And on the obstructed vision, he hasn't paid anything. We've issued warrants at least 3 times. What, he just decided to walk in today? Hang on, put your hand down, please. He just decided to walk in today? Is that what happened?
Your Honor, he indicates that he is on parole, and his parole officer had maintained that he needed to clear out.
Oh, yeah. Well, I see now. The parole officer ordered you to come over here. Does he work?
Yes, Judge, he works at Midwest Paving. He also is taking care of.
I am not giving him another personal bond. I'm telling you right now, if he doesn't have any money, he's going to be sitting in jail for a while. You've been blowing this off and blowing this off. You understand what I'm telling you?
I've been incarcerated, sir.
No, you got out in 21. That was 5 years ago.
I got out in 21. They never informed me that I had any warrants. Only one
Sure.
they informed me that I
Don't
had.
start raising your voice with me. You're not raising
I
my.
can't hear, sir.
Okay. All right. Good enough. You came here August 30th. I gave you a personal bond, and I gave you a court date of September 22 of 21, and you didn't show up.
I don't remember coming here in September, sir.
Well, maybe I arranged you on Zoom. I don't know what to tell you. But I gave you a court date for September 22. I told you had to appear in person, and you blew it off.
I don't recall.
Well, I don't care if you recall or not. I wouldn't write this down if it wasn't truthful. I hope he's got some money. I'm telling you, I'm not going to play this game anymore. It's been going on for 9 years.
Your Honor, just on a positive note, he does have a valid driver's license, and it's unfortunate Brownstown's not the building, so we would have been able to drive someone there today.
I hope he has money. Tell me he has money.
Your Honor, he indicates that he gets paid every 2 weeks. I believe his next payment is going to his next paycheck's going to be next week.
I can call my fiance to see how much she can.
Good. You're gonna have to. I'm gonna give you,
I need.
I'll tell you in a second, but be careful with your attitude right now, okay?
Okay.
All right, all right. Well, here's the problem. I don't like it when people don't show up. And I gave you a break when you came in here probably, and I can see myself doing it when you said, Judge, I'm in custody. I might have arraigned you on Zoom from a jail. And I gave you a court date and told you to appear in person, and whether you remember it or not, that's what happened. And then you blew it off the court date. 2,510% on that case. And I will give you I tell you what, I'll incorporate both of those. 2,510% on the A file, and on the B file, I'll simply incorporate that CA, and 2,510%. You cannot. Did we cancel this warrant? We did, didn't we, Heather?
Yes, Judge.
All right, give me a new pretrial date as soon as possible in case he can't come up with the money. I'm going to be more fair with him than he has been with us.
All right.
Okay.
I'm not sure the date I put on there, so this.
Oh, I'm sorry. Oh, we can do it on 9/9. I hope you're going to be able to post this. Fine. You going to be able to post?
I don't know how much it is. I don't have it with me.
$250.
I have to call my fiance to see how much.
We'll let you call. We'll let you make all the calls you need. Okay. 2,510%. That'll be your pretrial date. Make sure he's appointed a lawyer, and we'll go from there. Okay.
What time did I give, Judge, on the 9th?
9 o'clock.
All right, thank you.
I'm sorry. What did you say, sir?
The date?
September the 9th.
Okay.
Okay. So you come up with the 250. This is going to work out okay.
Yes, sir.
But you can't keep ignoring me.
Yes, sir.
All right.
Yes, sir.
Okay. Good luck.
See you in custody if you can't come up with the
Yes, he's going to have to lock him up now. He's going to let him make some calls, though. Do you have your phone? Let him make some calls. Thanks, Mr. Shemke.
Good morning. This is Judge Middleton calling. Mr. Stickley would like to know if we could see September Knowles.
Oh, my goodness.
Yeah, I hope she's okay and awake, but I'd like to see her in my courtroom. All right. All right. Thank you. Bye. Apparently she got picked up either last night or the night before, and she has 9 bench warrants.
How many?
9. You were here the last time, and maybe Jeanette was. She had 8 cases. I set bond at $250
Yep.
per case.
We're both.
And somebody posted it, and then she promptly failed to appear once again.
It's kind of like a fundraiser for the court.
What?
It's kind of like a fundraiser for the court.
I don't know.
Some
don't get to
organizations
keep
sell
it.
candy bars. Other people.
I don't know what to do with her, but I'm gonna hold on to her until we can at least get an attorney for
It's sad.
I saw when I got in this morning about 7:15, I looked at the jail roster and saw that she was on it. Shayna was gonna put these in my queue. Oh, there they are. Thank you. Although that's not all of them. 1, 2, 3, 7 of them, but there's 9 total. Good morning.
Good morning.
These are multiple files regarding September and Knowles. Here with me at the court is Chief Public Defender, Mr. Keith Stickley. Here on the video is September and Knowles. Miss Knowles has a terrible pattern of not appearing when she is supposed to. We had a recent set of arraignments with 8 separate cases. I set a $250 bond in each case, hoping we could get the matters to last pretrial. The defendant posted the bonds and then promptly failed to appear for the pretrial conference that was set. Yes?
Hold on. May I please have an officer present in this room?
Say that again?
May I please have an officer present in this room?
Oh,
Due to
there's
the
not an
fact that
officer?
I don't trust the Polycom due to the fact that I was hacked by my security department. With my security department, ADT is linked to the fire department, the hospital, EMT, and obviously you guys are aware of what happened.
Let me ask you a question.
And I was already informed by, I mean, Judge Pattison even explained and said I mean, he told me that I was a victim. So I don't understand why I'm being attacked when I've done nothing wrong, but have been left to walk when I was robbed and fucked over. Pardon my language for swearing while I raise my right hand. But I think with all fairness and all due respect that you should hear what I have to say.
Well, I'm not unwilling to do that, but let me ask you a question. How did you get arrested either last night or 2 nights ago? When and where did you get arrested?
I got arrested in Kalamazoo County. There is a false dispatcher that is calling the cops the police company. Right? And by the time I get inside, this is all muting back and forth. It's cutting in and out.
All right, I'm sorry. Do you have any Kalamazoo charges?
No, they're all taken care of.
All right,
I'm
that's
served.
good.
I am a victim, and that has been verified. And I would like,
I won't disagree with that, but you also keep doing things that call you to the attention of
I'm not trying
the
to
police.
do anything wrong. I'm
well,
trying
all
to
right.
get my life back in order. And when I do that, I simply get pulled over. Listen, I can talk to an officer from Kalamazoo County, from St. Joseph County. It can be a sheriff, a city cop. I mean, it doesn't, I can make an interaction with the cop, and the cop will chaperone me to where I need to go with no problem. And then the next cop will tell me, just stay off the sidewalk. Or the next cop will tell me,
all right, well, let me tell you what, you have very little insight into how dysfunctional you are. You have 9, now, I just talked to you a couple of weeks ago. I gave you 8 bonds. Somebody posted your bonds. Who posted the bonds?
my friend who is willing to, I told him to be present. And I would call him at 8 o'clock. I told him to be aware that I might be called in first thing in the morning by him. He has signed all the way, and he is willing to pay whatever fines and costs for me to get out of here today, so I can proceed with life, do what I have to do without being falsely accused or wrongfully detained or picked on.
All right, well,
and that is exactly what's been happening to me. My family is willing to dispute this. I don't want to sit here and rot. I'm not going to do that. I don't think that's fair, Your Honor.
Well, I'm very disappointed. I talked to you at length. I gave you these 8 bonds, and you stopped.
And you didn't get it.
You promptly paid me back by not showing up for court. You posted 8 bonds. This friend of yours foolishly posted these bonds, and then you didn't show up again. You have all 9 of these cases you failed to appear. We caught you. I set 8 bonds, and you failed to appear once again. Now I need to go through these one by one.
Take care of as well, Your Honor. I told you my home was robbed. My home was too.
All right. Well, none of those give you permission to not show up for court. I'm going to mute your microphone, and I'm going to tell you about each of these.
Your Honor, can I make an inquiry?
Yes.
And I understand that at this time, Miss Knowles, I don't believe has been.
You might want to keep your voice up so she can hear you.
I'm sorry. At this time, Miss Knowles, and my understanding is, and not having personally been assigned to her cases, but just helping out with the arraignment process, has she been, and I know that she hasn't been charged with a felony to my understanding yet, but that doesn't necessarily negate the fact that she might be eligible for evaluation by the center.
Well, she may be. I was trying to hold on to her long enough to have Lauren Frank from Pivotal work with her the way we did with some other clients, including Elizabeth Conway and some others, to get some sort of a plan. But she continually posts bond and fails to appear, or gets a citation, fails to appear. So I think that may be an issue. Luke Knopfinger is actually her counsel of record. She has an attorney on all these cases.
Right.
So, Ms. Knowles, let me go through these. I've muted your mic, so I can't hear you, but I want you to hear me. This is gonna take us a while. As I told you last time, these are all over the place. On March 11th, you were charged with being a disorderly person in the city of Three Rivers in file number 26427OM. That allegedly occurred at Applebee's. Walked into Applebee's harassing the employees and customers, cussed people out, made obscene gestures while on foot. So they gave you a citation and an appearance date, and you failed to appear. The next case, I don't think these are in chronological order, is file 26127. That one occurred allegedly on June 15th at 7:06 p.m. in Constantine. September was standing outside the Harvey house and then entered after being told not to go in there. So they gave you a ticket for trespass and an appearance date of July 2nd. You failed to appear on July 2nd. So one's in Three Rivers, one's in Constantine. And the next one is March 30th. The file number is 261511 3:09 a.m. A littering and disorderly person in the city of Three Rivers. I'm not clear where that was. Next, we have file number 26672. That is April 7th, Main Street and Industrial Parkway in Three Rivers. Disorderly person. You got a citation. The appearance date was May 4th, and you failed to appear. 3:09 in the morning. Not much good happens that late. Then in file 261132, you got a ticket at Arizona Boulevard, disorderly person, at 10:40 p.m. on June 6th. You had an appearance date of June 23rd, and you failed to appear at that time. 261311. June 5th at 8:24 p.m., a disorderly person in Three Rivers at Main Street and Portage Avenue, right downtown Three Rivers. Your blood alcohol was 0.03. Eesh. That's very high. And again, you failed to appear for that. File 26953. West Michigan Avenue, Three Rivers Fire Department, May 19th at 5:18 a.m. Trespass. Not sure what that's about. You had an appearance date of June 2nd, and you failed to appear. File 26982OM. Another disorderly person, Main Street and Fourth Street in Three Rivers. 1:42 a.m. You were a breathalyzer of 0.254. Again, they gave you an appearance ticket. You were to appear on June 9th, and you failed to appear. Then file 26386. 3:09 a.m. March 2nd, Centerville Road, Sturgis. Disorderly person and littering. You were to appear on March 18th in front of Judge Pattison. Anyway, on every single one of those citations, you got an appearance citation and failed to appear. I think there's 9 of them. Then you got picked up on a succession of bench warrants for failing to appear. I arraigned you, made sure you had an attorney, set it for an attorney pretrial, and again, you failed to appear for that. So not to mention all the previous times that you failed to appear. I'm going to set this for attorney pretrial with Luke Nossinger, who's been appointed as your attorney for September 4th.
Before we do that, make a brief motion of like this comment.
Yes.
So under MCL 300.6025, I'm going to formally request that she I'm very familiar with this adult. I understand that she has assigned counsel. I don't know getting anywhere with this. And I don't think that she's able to remotely assist in her own defense here right now, multiple times. I think the board has MC, I think it's MC 204 to order that. I would ask them to sign that and we can stop this and have the state perform a competency evaluation, either at the jail via video or into the center. I think that we're at the point where she's not able to rationally system. It's where the office and we're just delaying. I think the inevitable has to happen before we get it out.
All right, thank you. Ms. Knowles, he's asking that I have you evaluated for mental competency, which may happen. The problem with that is you could, for as much as a year, waiting for the evaluation to take place and for the reports to take place. And I've wanted to hold on to you long enough to have you in jail for a few days to see if you are clear-headed enough to discuss this. Because at our previous arraignment and this one, you were making lots of irrational statements. There's 9 separate cases all over the county. There's another one that was in Leonidas that I don't even think we addressed. Sturgis, Constantine, Three Rivers, Applebee's, Pizza Hut, the fire department, the hospital. You're causing all kinds of ruckus. So I'm going to take his motion under advisement.
If I just clarify one thing on that too. If you're on a work with that, she can still be released on bond. You can still sell bond. And if she doesn't show up to the forensic center for the court rule, then at that point she should be taken again, held without a hearing until that point would happen. So if you have any questions about that, I appreciate it, but I think we're kind of.
All right. I don't wish to give her a bond. I don't wish to release her on a bond until at least September 4th. I want her to have an opportunity to discuss this with Mr. Nossinger. I'd like Pivotal, our jail staff, to meet with her and see if there's an option. If there isn't, we can then follow the path that you're suggesting. Ms. Knowles, you failed to appear in these 9 cases 9 separate times, plus the 10th time when you failed to appear again. I have muted your microphone. I know there are things you want to tell me, but I'm telling you, we're going to set this for a pretrial next Friday. You're going to remain in jail in the meantime. I don't know who your friend was who posted your bond, but he didn't really do you a favor. You got out of jail and then promptly failed to appear again. If I were king of the world, I would forfeit all those bonds and he could eat the 200 that he posted. So could quick bail bonds. But we need to hold on to you long enough to see what we're dealing with. So, bond is denied and the unusual step of misdemeanors until September 4th, 2026. For further review. I'm gonna make a referral to Pivotal. We need a better plan than this. You get a ticket, you don't show up. You get another ticket, you don't show up. You get another ticket, you don't show up. And even if, let's say I give you 30 days in jail or 900 days in jail, on the next day you're gonna get out, we're gonna be right back in the same circumstance. So I'm holding on to you. We're gonna get 10 or so clean days and see what we're dealing with. I will see you on September 4th. I'm gonna make a referral to Miss Frank at the jail. I'd like you to cooperate with her. And I'm gonna let your attorney, Mr. Knopfinger, know that you are in custody. All right, Miss Knowles, I'll see you next Friday.
Yeah, we can ask her. That's fine.
Mr. Stickley, I'm not sure that I recited every single file because I remember there was a Leonidas incident that wasn't in on base. At any rate, all files, whether I addressed them or not, are gonna be set for that September 4th date. And I will make a referral this morning to Pivotal and see what they can do. So your motion may be apt, but we'll see. All right, this is Alexander K. Pappas. File number is 252180. I could not find a probation violation petition in the file. I found a probation status report, but I didn't actually find a PV petition.
I do not have a copy of that.
Uh,
It
this-
should have been filed for 8 and 10. Need me to go ask Jenny if she can find that?
Jenny's not here.
Oh,
At any rate, let's go with what I do know from the status report. We were placed on probation on February 25th for operating while impaired. And then right off the bat, things didn't go well. He didn't show for testing in March. Then we just found out we're dealing with a meth in March. And then you did a couple days in March. Defendant was on probation for less than a month and started to have issues with testing. This is the very reason we do testing, to catch these issues and address them as soon as possible. This case, it was caught pretty early and able to be addressed by service and support were increased. This was an OUIL case, and because of our testing, we were able to gain more insight into the defendant's struggles. He's now seeing a therapist, going to weekly meetings and testing weekly. So the recommendation here is that probation be continued.
Your Honor,
Yes.
I may speak to that. After I filed this report, things went more south. And I spoke to Mr. Pappas this morning, and he said that he just kind of figured that I was going to recommend the max and kind of threw his hands up there. He said that he thought I told him not to bother calling anymore because he didn't report in July or August. And I think he's just struggling with addiction and kind of went like this at this point. He had 1, 2, 3, 4 more meth tests and 2 missed. And then we ended up stopping testing him because it just wasn't doing anything. And I was hoping he'd take that money and pay for his old outstanding fines and costs and towards probation. He did make a $100 payment this morning. But if I look at this as a OWI case, I mean, technically with all the testing issues, you could go to the max. But if I look at what he might have been sentenced back in the beginning, I'd probably be looking at like 10 days. And it's kind of my recommendation at this point, we're not accomplishing, and I don't think he's ready to do any changing. He has always been very respectful to me. But I always wondered if there was something going on because it always seemed like he was kind of like not coming completely clean. But like I said, he was always respectful. I just think we should just give him the jail days and be off his back at this point. It's my recommendation. Revoke it. And he also missed his VIP again in late May 28th.
All right, you got a ticket for operating with a blood alcohol of 0.17 or above, which is high blood alcohol. Was reduced to your blood alcohol at that time. Well, we'll get to that in a minute. It was a 0.171. He had a lot of other baggage on here. You had a jury trial pending. And I think that resolved with a plea to disturbing the peace. I ordered 7 days jail credit 3, 7 days jail credit 2, leaving 5 days. Three are deferred, so I think you had a weekend to do.
Yeah, and he did that in May.
So there's 3 days of jail left under the original sentence.
That's what I have, Your Honor.
Daniel did a good job sort of explaining this. The reason why we do testing is to figure out what we're dealing with. We're dealing with more than one issue. And then we learned it was a methamphetamine issue, which is very difficult to treat in the context of a drinking driving probation. So it's the allegation that you violated your probation by failing to testing positive for other controlled substances. You have a right to have a hearing on that, where I could appoint an attorney. The original attorney was Paul Gibson. And we could have a hearing where it'd have to be shown beyond a preponderance that you violated the terms of your probation by either missing testing or testing positive for methamphetamine. Daniel is proposing that we don't beat you up any further than the original probation, which was 7 days. You ended up doing 4, which leaves 3 days to serve, and revoke your probation and get off your back. You also failed to do the victim impact panel, which would be an additional day of jail. So this just didn't work very well. So Mr. Pappas, you have a right to have a hearing on this. If you wish, I can appoint an attorney to represent you. Or if you admit to the violation, failing to go to the victim impact panel and testing positive for methamphetamine, I'm going to revoke your probation and give you 4 days in jail, and I guess call it good on the fines and costs. What would you like to do here today?
Your Honor, can I do the time on weekends?
Yes.
I'll.
Where are you working?
I work for a company called Bongo Benton.
Oh, you're still with them?
Yes, sir.
Good. Struggling with meth and working a full-time construction job is not easy. Where are you? Are you still at the same address?
Your Honor, it's my mother's house. Yes, I'm at the same address. She passed away the 24th. She had been in hospice.
24th of
this month.
Oh my.
I've been.
Who's your mom?
Micheline Pappas.
I'm sorry.
I was running back and forth to Corwell Health and Stevensville as much as I could. It's just been a hard time, and
So are you gonna stay in that house or the house is gonna be sold?
it's gonna be sold. I have 1 week.
Oh. All right. Other than what I said to you here, did anyone promise you anything to get you to plead to this
No,
or threaten you?
no.
Do you acknowledge that you violated your probation by failing to attend the victim impact panel in May and continuing to test positive for methamphetamine?
Yes, Your Honor.
Wish I could wave my wand and cure that problem. But as I indicated, it's hard to do in the context of a drinking driving conviction. The benefit is they reduced this all the way down to impaired. So you got to keep your driver's license, at least a restricted one. Once again, I could appoint an attorney and we could have a hearing on this if you wish. And you understand you're giving that right up by entering this admission.
Yes, Your Honor.
All right. I'm gonna call it 8 days jail, credit 4. Thinking 4 to serve, which shall be administered on weekends. We'll have the probation department arrange that. The jail doesn't like weekends. They asked me to quit doing it, but I don't want you to lose your job.
Thank you.
I'm gonna waive the remaining fine and costs and probation is revoked. All right, Mr. Pappas. Like I said, I wish I could fix this. You got a lot of baggage on there and you got grieving to do. It doesn't turn off like a switch. I'm sorry for your mother. Well, I didn't know your mother. I know River Street. But I'm sorry. If you wait just a minute, Mr. Frazine will go with you and schedule those jail days. All right. Good afternoon. You're Joshua Allen Ottinger. We met. We've been seeing a lot of each other here in the month of August. Allegation is that on May 8th, you assaulted Rebecca Jo Simmons, an individual you had a dating relationship with, charged as a second offense. That is a misdemeanor, punishable by up to a year in jail and a fine of up to $1,000. He pled not guilty to that charge. We had an attorney pretrial. The matter was set for a final pretrial. In the meantime, you got arrested on another assault charge in file 261409, and you're bound over to circuit court, and the case is 2626253 FH or FH, I think, or FY. It doesn't matter. Mr. Bush, what's the status here?
He would like to reach a comprehensive resolution of all of his cases. Vincent's asking this case be adjourned. And the author is, might as well put on record, I probably won't be his attorney because my retirement from criminal practice is coming. So it raises a couple of issues that we do need to talk about.
Unless they get the other case tried before the end of the year, and that's not likely. That a August case will be tried between now and December. They got lots of cases already in the pipeline. All right, well, but do your obligations to your clients end on October 1st, or you just won't accept any new cases?
I understand that. Find someone to take over the case and things like that.
All right.
I know the court can't do anything, but it certainly makes sense that Mr. Gibson would be taking over this case too.
Yes.
I guess that's Mr. Stickley's call.
All right, bond here was posted
that's the case, he's not getting credit.
Well, I don't think it was posted. It's 4,010%. Yes, it was posted. And then he got arrested on the new charges and had been in custody on the new case for 36 days. But I guess I don't need to make a bond ruling because I believe he's posted this bond. And as far as I know, it has not been revoked by him or the surety. Make sure. Bond posted. Yeah, a bond is posted, so he's not in custody on this charge. What I am going to do is I'm going to set a regular attorney pretrial rather than a final pretrial for October 2nd. I will have a new attorney by then. Then that gives a little more than a month to discuss resolving both cases together. The bond violation is that he violated the bond in this case by the charges that resulted in the subsequent case. He was not to have any contact with her, and he certainly wasn't engaged in any assault or threatening behavior. So the conduct of the new case is alleged to be a violation of this bond. And as a practical matter, even though he's posted this bond, he's been in custody for 36 days since that date. If I revoke his bond, then I'm going to have to, well, I could revoke his bond. Mr. Gabriel, what's your position regarding the bond violation?
Your Honor, obviously, if a bond violation ends up resulting in a probable cause determination of another crime, court, I would think, and I don't know what his position is going to be, but if I were him, since he's not going anywhere, I'd ask that the bond be revoked so that he gets credit in case something happens. I mean,
well, he can make that choice,
right?
But I can't. I have to have some evidence that he violated it. But right now, there may be a question as to whether you're getting credit on this case because you've posted bond in this case. So in the instant case, you have just a couple days credit. So if you voluntarily relinquish this bond, there will be no question of the fact that you're getting jail credit in this case for the time that you're serving. Mr. Bush, you want to discuss that with him?
He would agree for the revocation of the bond in this file.
All right, if it becomes an issue and he wants it to be reinstated, he can ask for it. As a practical matter, well, this is a second offense. It's punishable by up to a year in jail. This is going to be resolved before that. So, Mr. Ottinger, you agree if I just cancel the bond at this point, it will be clear that you get credit for the time you're serving. Is that agreeable with you?
Yes.
All right. All right, the matter is adjourned for a pretrial with attorney for October 2nd at 8:30. In the meantime, the defendant's bond is revoked. He will remand to the custody of the sheriff pending resolution of each of these cases. All right, Mr. Ottinger, you're good to go. Trade him for Casey Willis.
That's correct. Mr. Gibson.
Miss Willis, I can't find are you booked in under a different name?
No, sir.
Okay. How long have you been in jail?
Over 2 weeks in St. Joe County.
Oh, wait a minute, there it is. 13 days jail. All right, this is file number 24390 SM. People versus Casey Elizabeth Willis. Miss Willis, it is alleged that she assaulted Joan Gritzmacher, a former resident of her household in Fabius Township in January of 2024. The defendant was arrested on that charge in 2024 and posted bond. Then she failed to appear for her arraignment in June. She got arrested and she was in custody from June 19th of 25. Anyway, a year passed. She failed to appear in June of 24. She got arrested in June of 25. Posted bond on June 28th. So she did 9 days at that time. Then she failed to appear again. The matter was adjourned a couple of times, and a final pretrial was scheduled for October of 2025, and she failed to appear for the third time. Bench warrant was issued, and the defendant got arrested on August 17th. And so she has 13 days from that point. So she has 1 day at the time of the initial arrest, 9 days at the time of her second fail to appear, and 13 days now. So I guess that's a total of 23 days credit. Mr. Gabriel, what's the status here?
Your Honor, in this case, we've offered her an opportunity to enter a plea to a misdemeanor charge of disturbing the peace for the incident that occurred and that we're talking about here.
All right, let's talk about that. Domestic violence or domestic assault is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It would require that your firearm privileges be suspended for at least 8 years. The prosecutor, Mr. Gabriel, has agreed to dismiss that charge or you plead to a charge called disturbing the peace. Disturbing the peace is a little bit of a lesser misdemeanor. It's punishable by up to 90 days in jail, fine of up to $100, and it doesn't carry a firearm restriction. Do you understand the charge?
Yes, I do.
And are you going to plead to that charge?
Yes.
Do you understand that by pleading to that charge, you'll be giving up your right to have a trial in front of a judge or jury? You understand that?
Yes.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Knopfinger has been appointed to represent you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have the right to be represented by an attorney. As I indicated, Mr. Knopfinger has been appointed to represent you. You'd have a right to take the witness stand and testify on your own behalf if you wish to. But you don't have to because you have a right not to testify. If you did not wish to testify, the judge or jury could not hold your silence against you. You have a right to have any of the witnesses for or against you subpoenaed to come to court, so they could be questioned under oath, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes.
Now, I've been through this a couple of times back in 24 and 25. You were living at the Young Monroe Trailer Park with Joan Gritzmacher, is that correct?
Yes.
And that was your boyfriend's mother.
Yes.
And you and John have been struggling with heroin, at least at that time. Your mother-in-law is in a wheelchair, correct? Or your
No, she's not.
Oh, there was a wheelchair ramp.
Yeah, but she doesn't use it.
All right. Did you and Joan Gritzmacher get into a scuffle out in front of the trailer?
I would say we didn't get into a scuffle. Like her son stood between us. She was like trying to attack me and he kept trying to restrain her.
Did you bite her in the hand?
No.
She got taken to the hospital for a bite wound on her hand.
I know.
But you didn't bite her.
No.
But you were scuffling with her.
We never physically touched.
All right. Well, disturbing the peace is different than assault and battery. Was there a quarrel, argument, disturbance in a public place? Doesn't matter who was right or wrong or who started it. But it sounds like you and your boyfriend's mother got into it out in front of the trailer at the trailer park. Is that safe?
Yes, it's safe.
All right, then you went AWOL, then we caught up with you, then you went AWOL again. And you've been in jail since. Where did you get, you told me this at the arraignment, but I can't remember. Where were you when you got arrested this most recent time?
Portage actually, but Kalamazoo.
Are you and John still together?
No, he's in prison in Indiana.
John Williams. So you have no reason to have contact with Joan Gritzmacher.
No.
13 days plus 10. You've been in custody for 13 days. Have you been experienced withdrawal symptoms?
They're over now, but yeah, I did.
Did they medicate you at all, or they just let you go through it?
They gave me like some comfort meds, like ibuprofen and like anti-nausea medicine and stuff.
You're rocking back and forth in your chair, and I see that behavior often sometimes when people are struggling with recovery or going through withdrawal or have other issues. Where are you going to go if I let you out of jail?
My grandma's house. She lives on Portage Lake in Mendon. Or it like depends because I'm looking at drug treatment court in Kalamazoo.
Or you have Kalamazoo charges pending?
Mm-hmm.
Do you have a hold?
No, I got PR bonded there and then brought here.
Judge, she has a pending case in circuit court that I represent her on. We have a status.
Pending case here also? All right, then she's got other fish frying and she's probably being held on something else. I'm just gonna do 23 days credit, 23 days. This is 2 years old, no longer has contact with the complaining witness. She did 1 day, then 9 days, then 13 days. Let me look at this again. 6-1.
I was broken.
Yeah, 1 day credit. I'm gonna order 23 days, credit 23 days. A minimum allowable fine of $125 for 2 additional days. It'll get swallowed up by what you're doing. I'm gonna go concurrent with open felony case.
Thank you, Your Honor.
All right, Miss Willis, you need some more clean time. And 13 days is a good start. All right, you can go with the officer. You're good to go.
Thank you.
All right. That's at least no problems. All right, the next matter is our sentencing. All right, this is file 261425, People versus Skylar Reynolds. Mr. Reynolds is charged with domestic assault. The complaint was originally filed, then it was amended to become a felony. Assault with intent to do great bodily harm and murder by strangulation, which are a 10-year felonies both. Interfering with a crime report was a 1-year offense. Defendant pled to domestic violence aggravated, a 1-year offense. Wait a minute. Yeah, pled to aggravated domestic assault. The matter was set for sentencing today at 15 days on August 11th. And according to the jail as of today, he has 31 days. I did get access to the police report and I got victim input. I was given a copy of the victim impact letter from the complaining witness, Morgan Napier. She's completely satisfied that she didn't even wish to have a charge. But her position would be that we simply sentence the defendant, let him go back to Ohio and deal with his parole violation there. Mr. Gabriel, you have any additional input on this?
No, I just indicate, our notes indicate that the defendant woke up in a bed, started assaulting his girlfriend, grabbed her by the neck, put his hands over her mouth and nose so she couldn't breathe, and said, quote, "I could kill you." Put pop in her mouth to keep her from yelling for help. Took her phone from her. All of that is in the police report. And then we have a victim impact statement that actually seems to say, gee whiz, how could we dare prosecute this individual? Well, that's why. And so I understand he's done, I think you indicated 30 days in jail. If the court feels that's enough, fine. I'm not going to argue with the court, but in light of what she says happened before, and then now supports him at sentencing.
And we've seen that.
Too often.
In my opinion, all the charges should be dropped. But they weren't. He entered a plea. And he's wanted in another state. Mr. Knopfler, got anything you wish to add?
Yeah, I was just particularly touched by the comments about how his relationship and how maybe the decisions he's made has affected those around him, including his children. I would ask the court to, do what it sounds like it's inclined to do. And then I know that he has to face the music in Ohio. Thank you.
I don't want to give up on him getting better. He's got family that's interested in him back in Ohio. But just like Ohio, we have long memories here, and apparently they have one there. You own this at the time of your plea, and you were ready to go back to Ohio and deal what you needed to deal with. They have a hold on you. I'm going to order 31 days credit, 31 days. Minimum allowable fine of $125 or 2 additional days, which is sort of a legal fiction. It'll get swallowed up by what you're doing. May be released. You're going to have to waive extradition to go to Ohio, but you may be released to Ohio. My recollection is you already waived extradition. Have you done that already?
Not to my knowledge.
All right. Well, they can't send you back to Ohio unless you waive extradition or they get a governor's warrant, which you could sit for another 90 days. So it's up to you. But if you waive extradition, they can immediately get you back to Ohio, get a lawyer appointed for you, and get that case started.
Okay.
As far as this case is concerned, Mr. Gabriel's right. It's a little worse than she paints the picture. It was a felony with a strangulation aspect to it. But as it turns out, you're not going to go anywhere. She doesn't want me to proceed. 31 days credit, 31 days. You're good to go.
Court does call the case. People versus James Johnson.
People vote matters.
Your Honor, good morning. May it please the court, Lowell Friedman, P5625. Your Honor, I appear on behalf of case 2026-26F5-5608FY.
Got to move over. He's got to be on. Thank you.
Sorry, Your Honor. Oh. Morning, Your Honor. J. Grant Miller, P5858 on behalf of Mr. Johnson on the other matter.
Johnson, state your name, please.
James Johnson, how you doing?
I'm doing okay. All right. All right, what are we doing?
Your Honor, I believe the discovery in my case is complete. I believe co-counsel indicated the same. We were just requesting a brief adjournment. I had begun some settlement negotiations, but this is the first time I've talked with co-counsel, and it sounds like his case is the controlling case. So we're just requesting a brief adjournment to see if we could resolve the matter.
I agree. I'm now in follow-up discovery. Frankly, I have not had a chance to review the newly provided discovery. We'd like to come back before you, Your Honor, for an adjourned PCC.
Okay.
It's already waived his 21 days. I'd like to see if there's a resolution available after watching the discovery. Otherwise, we'll proceed with the exam.
And Your Honor, the co-defendant, Mr. Gardner, is currently scheduled for PCR.
All right, so I'll adjourn his PCC to the 17th.
Thank you, Your Honor.
All right.
Your Honor, if we could address bond.
Yes, you may.
Your Honor, my client actually has been taking advantage of the Dawn Farm programs inside the Washtenaw County Jail, but he's also taken it upon himself. He has found another treatment facility who has availability and a bed. And I'll let him speak as to the name of the place. It is available for him tomorrow. So we were just requesting a change to release to treatment. I believe the court has a greater familiarity with my client than I possibly do. I've only known him for a few weeks.
Kind of way too much.
He asked that he be able to address, Your Honor, as to that, as to the bond in the treatment facility.
No. And you're joining in this, I presume.
Holding hands.
Right? All right. Well, all right.
Long arms, Your Honor.
So, what do you want to tell me? All right. Never know how that's going to go with him, because sometimes he comes in here angry and then he starts saying stuff he shouldn't say. And always say those days, Mr. Johnson, look, that never out good for Mr. Johnson. Yeah, for sure. And this didn't. No, not at all. So I'm gonna let you talk as long as you're gonna be courteous, but always. No, say always. right. Not say always. Right. You're right. I know I'm right. All right, go ahead. What do you want to tell me?
So, like you said, the last court proceeding, I know expect, out of me. So I did take the proper steps to try to get into treatment. I did Oakdale and Canton. I actually wrote you an email too. I sent it over to your clerk. But I took the treatment. I made the several calls over the phone, third party through someone, and got myself registered in treatment for Friday. I got the bed. I told him I'll be released or I assume I would be released today if I was to get my bond reinstated. But I got the bed space for Friday. I'll be placed in the 21-day program through Oakdale Treatment Center. And I apologize in that letter as well to community corrections for my behavior and the way that I spoke over there that day. Like I said, there was some stuff going on and personally with my relationship. So I took it out on everybody else. And I apologize for.
You know what your problem is? Well, one of them. When you're using, you're a horrible person. I'm just going to be blunt about it. You really are. And you have better moments when you have your sobriety.
Yes, sir. Yeah, for sure. And I realized that too. So I took the steps to do what I need to do, to try to show this court that, I'm really serious. I got a lot of stuff going on, but now I'm working and stuff like that. So I'm just asking that the court will be considerate, to reinstate my bond so I can go through with my bed on Friday and continue to keep coming to court and doing what I got to do and show you that I can actually, do what I got to do and stand on my own like a man and handle my business.
And if I may, Your Honor, I did forward the information forwarded to me from Oakdale. I sent it to Ms. Feltis. That was Monday or Tuesday. I did call. They did confirm that he did have an appointment. They did have availability.
People have a response.
I would request that if the court does release the defendant to inpatient, that it's with a GPS tender, and that the instructions that if he, for any reason, leaves that inpatient treatment facility before it is completed or before he is discharged by them, including if he's discharged for behavior, that he is to report back and confirm himself into the Washtenaw County.
Sure.
That's perfectly.
I would sign that. So if you prepare that order, we can facilitate his release on the GPS tether. He's set for tomorrow.
Yes.
So I need that order as soon as possible so that we can potentially get the GPS on it today so that he can be free to go. But I'll sign that order.
Thank you, Your Honor.
Thank you, Your Honor.
Pardon?
Read the order right now.
Okay.
Won't be disappointed.
Thrown out. Don't
I won't
talk to me again.
I won't.
Me?
I won't. Next time I see you, I'll buy you some lunch or something.
What? No.
Oh, you don't want no lunch? All right, it's cool.
Huh?
Have a good.
Oh, yeah. See, the kind of lunch I want, you can't afford.
What?
No. All right, take care.
Got it.
All right. Court does call the case. People versus Darian Crystal.
Ready, Judge. Court shall feast the first assistant public defender on behalf of Mr. Darian Crystal, who is approaching. Mr. Crystal, when you arrive, please state your name for the record.
Darian Crystal. All right. What are we doing?
Mr. Crystal would like to waive his preliminary examination and go to the court for further resolution, Your Honor.
Crystal, is that correct?
Yes.
I understand examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes.
Do I understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts. Mr. Feaster.
Thank you, Judge. You waive formal readings and stand mute, Your Honor.
Defendant every way formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for September 9th, you said?
Yes.
September 9th, 2026, 1:30 before Judge Conlon. Bond will continue.
Judge, may I clarify his bond for him?
Clarify his bond?
I want to ask you a question on the bond.
Go ahead.
Thank you, Judge. This is a child support matter. Mr. Crystal wants to make sure his bond is set at the lowest possible according to the state statute. He believes his arrear, and I know we have the AG here. Perhaps she can give us what his.
I have his bond set at $2,324.75 cash, which probably going to tell me that it owes about 10 grand. I'm thinking.
Correct, Miss Attorney General?
Yes, Your Honor. He does owe $10,276.21.
Okay. It's set at the 25%.
I believe he wants to say something to you, Your Honor.
So they already took I'm confused. So if they already took the payment for the do I gotta pay child support and arrears? Or is it?
Yeah, you have to pay for children.
I know that, but
okay.
They took the payment, so
what do you mean they took the payment?
Because child support, I had the case yesterday at court for FOC yesterday, but they dismissed it because they already got the payment for what they were saying that I didn't even give, but I was coming out of my check, and I can't sit in jail because I'm gonna lose my job, and then I'm gonna be stuck.
But they got the payment. They don't have the full amount of the arrears.
Right, because I thought I can somehow get on a payment plan or something. I'm not sure. I'm new to this. I'm not sure how it works. But I know they took the payment and they dismissed it yesterday for my case for yesterday. So I know they dismissed that one because they have the payment.
And that may have been for your current.
Okay. So okay.
That's a current obligation payment, I believe you paid, Judge.
Is there, right. And this is regarding an arrears, but outside of the payment of the arrears, it's also a criminal offense not to pay child support.
Okay.
How where you are.
Okay. Okay. And I can't get a 10% or nothing off of this on my bond.
Okay. So here's how this works. That allows it to be set at about 25%.
Right.
You actually have the lowest bond that you can possibly get.
I told him that.
Because otherwise, it could be 10,000.
Can I get a closer?
Paid it.
Can I have a closer court date then? Because September, I'm just not trying to.
Sir, I get that from the circuit court judge. Your attorney's trying to move it up as fast as he can, but I don't have another date I can move you. What if it from?
Oh, you can do that. That's outside of the judge.
I can use a bail's bondsman.
Pardon?
I can use a bail's bondsman.
This needs to be cash. So no, because here's what's going to happen. You pay it through a bail bondsman. There's really no money there, which means that your child support arrears doesn't go down. So you pay a bondsman and still owe this amount. So what is happening here is 25%, and then the 25% is applied to your child support arrears.
So we're trying to move it as fast as possible, get it resolved, Judge.
This is the closest thing I have.
Oh, thank you.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Matthew King.
For your honor, we have a full.
Good morning, I'm Rob Jake Hill on behalf of Mr. King. Mr. King, state your name for the record.
I need a break room.
You need a break room? We met last night. You wanted an exam.
Why I'm not there? Why I'm not there?
What? You're not where?
There. Why am I on Zoom? Why am I the only one that's incarcerated that's on Zoom?
That's not true. I have
mean,
done.
well, that's what it looks like now. But why I'm
Mr.
not
King,
there, though?
Mr. King, they told me for security reasons, not necessarily you had to be on Zoom. I was just told that 2 minutes ago.
What security reasons? For my protection or theirs?
Do you want to set an exam?
Yeah, but I also want my rights don't want my rights being violated. Like I'm supposed to be there. I'm not understanding.
I'll leave it to you. Judge. I have to advocate on behalf of my client.
I want a breakout room.
Would you allow a breakout room? I hear you can make up to 3.
I did 1 today.
I know, but I hear the rule is 3 though.
No, it's not. The rule is actually 0. Well, first thing is I'm not bringing him up. If you want to set an exam, you can set an exam. I will, Mr. Killerwald, you find a machine to get onto. We'll put him into a breakout room and I'll call it back in a minute, but I'm not bringing him up.
Try and get on Zoom, Mr. King.
Neither for my preliminary exam. You too biased to me, man. It's always something with you, Simpson. Always. You abuse your discretion with me every time, man.
Judge Simpson.
Like
thank
you don't even know me, man.
And then we can put him into a breakout room so you can talk to him, Mr. Killerwald.
Would you have any idea who the judge is going to be if it set the exam?
I haven't said it yet.
Would you have a thought of who it may be?
It's not going to be me.
All right, thank you.
Or maybe it will be. Don't know. Court, did they go into a breakout room?
They are different.
They didn't. Okay. Court calls the case. Recalls the case. People versus Matthew King.
You're Rob J. Kill, behalf of Mr. King. Matthew, would you state your name for the record, please?
It's Antonio King.
And thank you. Judge, I've had a chance to speak with my client. We'd like to set an exam in this state.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 8th.
If you could stop the only thing holding the defendant, I would ask those that speak after it functions.
Judge, I normally go along with the prosecutor's request because they've done the same for me. But Mr. King is demanding that possible date. He wanted it 1 week. I told him it more than likely be 2 weeks.
Okay, thank you. Preliminary examination will be set September 8th, 2026, 9 a.m. That is before Judge Barr.
Thank you very much.
Bond will continue.
Thanks. Mr. King, I'll come down and see you this weekend.
Court calls.
Yeah, have a nice day.
But you couldn't hear over his laugh? Couldn't? I heard it. Of course, I said it, so okay. All right, we'll try it again. I'm so glad that I was not the one drawn to here. Just saying.
Who's he?
Court calls case of the people versus Taiwan Griggs. Your name, sir?
Alan Griggs.
Thank you.
We're just set for preliminary exam. My understanding is several things set for preliminary exam. We just
He already does.
Yes, it's my understanding.
When are those set?
He's got one with Judge First on Tuesday morning and one with us in the afternoon on Tuesday.
Oh. Well, he's got one with Judge Perry on Tuesday and one with myself on Tuesday. Probably unrelated case, however that gets said.
I'm gonna ask.
Well, you can come back to following.
Not sure if I can turn it around in 5 days here.
I got you.
But I don't know, these particular officers, I'm not sure their availability.
All right, let's do this then, okay? Since he's in custody, he's got 2 coming up on that day. I'll set a preliminary examination matter in these matters. I'll set it for the 1st at noon before me. Okay? Understand this though, I would, if the people can't get the witnesses there, I will adjourn it out.
Your Honor.
It's understandable, Your Honor. Thank you.
Okay, but let's see if we can get it resolved.
Your Honor, my client has asked that I address bond.
So I said something in 5 days and you want to address bond? No, go ahead, Candace.
My client is
See how this goes.
requesting that he be allowed to be released to treatment in this matter. He wound up being in custody because of his misdemeanor matter initially. He was an hour late for court, but he did show up. He did get to court, but because he was an hour late, it's my understanding the judge kept him and put him in jail, Your Honor. We are asking that he be allowed to be released to treatment. I don't know that the one for misdemeanor court has a release to treatment in it, but I am working to make that happen.
Who's that?
Which judge is that? Was it Garwood?
I'm not too from.
Your Honor,
Apologize.
I do believe it was,
It's out of 15th, you think, though?
I believe it is, yes.
And that, go ahead.
Your Honor, I'm going to be opposed. In 2024, the defendant gets an armed.
Look this way, sir.
Good judge.
Look at me. Go ahead.
We charged him with a resisting and obstructing case that happened in October of 2024, causing serious injury that resulted in an officer having his shoulder dislocated. In 2025, he gets another resisting and obstructing case. That one doesn't cause an injury. And then in 2026, the one we're here on today, he gets another resisting and obstructing a police officer. So I don't think there are bond conditions that can be satisfied. And while he may need treatment, we have an exam. We have 3 exams in 5 days, so it doesn't seem appropriate this time.
And Your Honor, again, my client, he acknowledges that he has a substance abuse and mental health needs, which is how he finds himself to be here. He does well when he is in treatment. As far as the causing injury, the allegations in that case, the officer tripped. While we understand, so it wasn't assaultive. He didn't harm it. He didn't push. We understand that under the statute that still counts, but my client wants it to be clear he never physically assaulted that particular officer. It
Just didn't comply and the officer got injured as a result of that whole encounter.
yes, but
Okay, that counts.
wants the court to know.
But if he had actually been compliant, then
I'm not a violent
happened.
person at all.
He just wanted me to make sure.
I'm gonna
Swear.
deny the request. I have him back in 5 days. He's got 2 cases before me. I don't have a problem retaking a look at it, but at this point, I'm not gonna change it.
And thank you for listening, Your Honor. We appreciate it.
Court does call the case People versus Antonio Washington.
Senior Assistant with and on behalf of Mr. Washington, please state your name, sir.
Tony Washington.
You may.
And thank you.
Go ahead.
It's come to the people's attention that the day after arraignment, the defendant did make one singular call to the victim in this case. I have listened to that call with defense counsel. During that call, the defendant does ask the victim if she is going to come to court a couple of times. He also it was a arraignment, someone will provide them to someone in some shape form. This time, it's on that bond, but I should the court decide to revoke the defendant's bond, also it's following text. Thank you.
Okay.
Thank you, Your Honor. Your Honor, call was short, as indicated, was only one call from the Washington County Jail. The plaintiff, Mr. Washington's wife, there was his bond included a condition that he could be released on tether. At the time of the arrest, all of his belongings were left there in the care of his wife. It's also my understanding, at least from listening to Paul, I did have an opportunity, that he did have other people attempt to contact her for this to obtain his cell phone so that he could be released on tether. Unfortunately, she was not taking those calls. Mr. Washington contacted her directly himself to ask for the phone to be provided to his father. In the course of what's appeared to be marital frustration over issues that were not related to the allegations in the police report, the conversation began to go south a bit. And at some point, as it's more of the back and forth in this southern part of the conversation, as opposed to the initial eastern part of the conversation where they were talking about the phone, Mr. Washington did ask in some level of frustration, well, are you coming to court? And that he knows is inappropriate, is that right? And he also knows now he is very clear that he should not have made that phone call, even though she was not responding to other persons that he had attempting to call her, such as his father and another friend of his. It is my understanding that once he obtained the phone and Community Corrections met with him and went over all the orders with him, again, very clearly, that he is very, very clear that what no contact means, and he has not had any contact. He also has not had any violations of the tether, is my understanding. And he has been just trying to make sure he appears in court and does the other things that he is ordered to do. We're asking that Your Honor, please give him a stern warning. He is very much aware that this was a poor choice, and we've talked about this in probably more detail than he would like. And so we are asking again that the court give him a stern warning that this will not happen again. And it has not happened since. Is that right?
Well, except that we don't know that, right? Because he's out. I don't know what he's done.
Well, I have.
And what?
I was going to say I have obtained a job since I've been out as well to pay.
Magistrate told you not to contact. They also tell you that there's another procedure that if you had to get your property, which is called a civil standby, you got to use that procedure. That's how you do that.
I didn't know nothing about it, Your Honor. As far as
you have an attorney, you could have asked them. You knew the magistrate said no contact. And then upon the contact, you're talking about the case. Can't tolerate it, and I won't tolerate it. So at this point, I will adjourn this matter out to September 1st. That's a Tuesday, 9 a.m. for a probable cause conference. Defendant's bond at this time is revoked. Defendant's remanded.
Thank you.
Thank you.
Well, I think the words defendant is remanded about the most stern talking to you can get. Wow. I don't think you get any better. Why I need to say thank you again to Vegas Starlight and Spec. Thank you both so very much for the generous super chat. I greatly appreciate it. Vegas Starlight put one in here. Apparently, it is National Just Because Day. I don't know really what that means, but it probably applies to the Wolfpack stuff. Thank you so much. And Spec said, Vega, I'm jointly donating just, because. Just because. Ladies and gentlemen, happy National Just Because Day. Just because. No other reason. I'm not even sure if that's actually a thing. Maybe, it may not. As far as I'm concerned, it is. But, yeah, it's been amazing. I think you're all amazing. Thank you all for being here for the stream. Thank you all for hanging out for my little collection of court cases from the day to the day. Come back tomorrow, Friday. We'll have more. Same wolf time, same wolf camp. I don't know. He's back there. Ladies and gentlemen, thank you so much. Yeah, Bat Boy is back. That happened. I'm still kind of in shock. It's been a long day. Been a lot of cases. The case in Texas ended today in a shocking way, and I don't know how I'm going to package it, but I've got to package it together. It's a pro se jury trial, and when the decision came down the pipeline, I had to listen to the decision 4 times to make sure I heard what I heard correctly, and I'm still not so sure. I don't know if I heard the name number 4 or 40. I'm pretty sure I heard 40. And it's just, oh my God. Ladies and gentlemen, I am your Lone Wolf Looseful, and we will talk more about that aggravated assault case later. For now, I am out. Thank you so much again, Vega, Spec, you amazing, crazy people. I don't deserve to have you. Bye. And remember, only you can take a bite out of crime. Bye.